Yesterday, U.S. and this is just to put a bow on that, if I can, tragic. And this is, as he pointed out, it happens more frequently than not that the executive branch, these huge government agencies, just pay no attention to Congress. This is, and they have an oversight role. And that's one place the media is supposed to work to help expose this. This is what we're trying to do here on Washington Watch, because the legacy media is a part of the left. Anyway, I'm going to wrap this. I'm going to move on to our next topic here, because yesterday, U.S. District Court heard arguments and testimony regarding a Louisiana state law requiring public schools to display the Ten Commandments in each classroom. Now, a lawsuit was filed against the legislation by attorneys representing a group of Louisiana parents, as well as Americans United for Separation of Church and State and the Freedom from Religion Foundation. An expert witness for the plaintiffs attempted to downplay the historical impact of the Ten Commandments in the history of the United States. So what does this have to do with the First Amendment, which Louisiana lawmakers are confident this law follows? Joining me now to discuss this is the Solicitor General for the state of Louisiana, who argued before the court yesterday, Ben Aguiñaga, who is joining us now from Louisiana. Solicitor General, thanks so much for joining us today.
Good afternoon, Tony. It's a pleasure to be here. Thank you for having me.
So, Ben, tell us about yesterday's hearing.
Well, it went well, and it was long. We were there from 9 o'clock in the morning all the way till 5 p.m. The judge was very engaged with the parties on both sides. As you just noted, there was an expert testimony that dealt with an evidentiary question, and the afternoon was all about the merits of the lawsuit. Threshold question: should this lawsuit even be in court, given that there's binding Fifth Circuit precedent that says this is actually not right, because there are no displays on classroom walls, and so nobody knows what they look like, and thus a judge doesn't have the facts it needs to decide the case. And then we went on to the merits, which you alluded to, and as we told the judge, this law is plainly constitutional. There are applications of this law that are consistent with the First Amendment, and thus it should withstand legal scrutiny. So we're excited to see how it went, and we're excited to see the judge's imminent decision in the case.
You're confident, as well as the Louisiana lawmakers who advanced this, that the recent Supreme Court decisions on religious freedom and expression open the door for schools to do just what this law calls for.
Absolutely. I mean, I think one of the things, and this should not be a controversial proposition, one of the things that the legislature recognized in this legislation, and that the Supreme Court has recognized, that the Ten Commandments have historical significance as one of the foundations of our legal system. And I say that's not controversial because there was a decision called American Legion from the Supreme Court in 2019, where you had 5 justices. You had Justice Alito, Chief Justice Roberts, and Justice Kavanaugh, and you had Justice Breyer and Justice Kagan, who joined in that statement that the Ten Commandments have historic significance as one of the foundations of our legal system. And so the legislature was well within its means to say, we would like Louisiana students to understand the role that those commandments played in the foundation of our system. And that's what the legislature sought to accomplish through the legislation.
Now, Ben, yesterday in the court, the opponents of this brought forth a quote-unquote expert witness, Professor Stephen Green, who was associated with Americans United for the Separation of Church and State. He was special counsel for them. He said that there's really no connection with the Ten Commandments and the founding of the United States. Number one, was his testimony relevant? And number two, was his testimony accurate?
No to both, Tony. I mean, the first point is it's not relevant. The Supreme Court has never said that an expert gets to dictate how a federal judge does his job in deciding what the law is. And so that was our whole point, is the court shouldn't even be considering this as expert testimony, because that kind of testimony is simply inappropriate in a case like this. But number two, he's just inaccurate. I think one of the most telling points of the examination of that witness is that when asked if his opinion was directly contrary to binding Supreme Court precedent, he said yes. He admitted on the stand that his view is directly contrary to what those 5 justices in American Legion said about the Ten Commandments. And I think as a factual matter, anybody who's been to Washington, D.C. would reject his opinion out of hand, because Moses and the Ten Commandments are all over Washington,
Right.
D.C. They're in the Supreme Court courtroom. They're on the gates, the doors to the courtroom. They're in the House. Moses is the centerpiece of the House of Representatives. That's who the
Right.
Speaker looks at, and all the other lawgivers look at him. So this idea that the Ten Commandments and Moses have had no impact on American history and the American legal system is just, respectfully, it's wrong.
Ben, 30 seconds left. What are the next steps?
So next steps, Tony, in this case is we're waiting for a court decision. He said he would issue a decision by November 15th, and we've asked him to move expeditiously. So if we need to, we'll go to the Fifth Circuit for emergency relief. There's a second case also pending in New Orleans, this one brought by a teacher. That case will be ripe for decision on November 6th, and so we'll be awaiting a decision in that case as well. There's a January 1st compliance deadline for schools in Louisiana, and so we hope that by the end of the year, schools will have clear legal guidance that they may and should and must comply with HB 71.
Do you think this lands at the Fifth Circuit?
I think it does, Tony. I think regardless of what this district court does, the losing party will take it up because there is binding Fifth Circuit precedent on the jurisdictional point. I don't think it goes to the Supreme Court because the jurisdictional question is so obvious to us and it's answered by binding precedent that there's really no need to go up to the Supreme Court. But it will go up on appeal.
All right, Solicitor General, I want to thank you for joining us, and I understand you did a great job arguing it yesterday before the court, so well done.
Well, thank you, Tony. Thanks for having me, and we really enjoy it. Have a good one.